He's 6,005. 6,005. Yeah. Because it's fairly close to the coast. Yes.
They're coming.
Sorry? She hasn't got any. I've been and asked. Sue, so we'll have to. I've got to go. Well, Sue's not here, is she?
She's on the slipway, isn't she?
Yeah. Is everybody ready here if they're ready? Yeah.
Yes.
Well, I think the first matter is the form of the hearing, in which, in the light of, thank you for your the email sent through your clerk.
Yes.
I think in the light of that, there is no dispute between the parties, obviously subject to the court, but it will be a public hearing using anonymised terms and streamed. So if the court is happy with that, I think we can move on from there.
Right. Yes, well, the court is happy with that. In which case, my clerk, I was keeping my clerk in case we needed to rearrange everything. So I think you're dismissed.
Thank you.
Yes, all right. Now, we are therefore doing this hearing as a public hearing. We are acutely aware that we need to use anonymised abbreviations at all times. We have been given a very useful chart, and subject to some slightly different letters and numbering creeping in once or twice, that's very helpful. So we'll stick to those, and obviously we've all got to do that, so we understand that. Moving to the substance, we have had some time to look at the substance of it, so you can rest assured that we have a relatively lively appreciation of the issues, and we're also very grateful to you both for your indication that you have enough time, but that's always a good thing. We usually met with the argument that you don't, so that's good. And we'll leave it to you to divide up the time as per your timetable. We just need to finish up by 1 tomorrow because we have another hearing tomorrow afternoon in a different case.
I think we understand that. We will finish by 1 o'clock tomorrow, and I've agreed with the learned friend that if I run over on opening it, then it'll come out of my reply.
Right. All right. Well then, Mr. Hollander, over to you.
Thank you. In the light of the fact that the claimant A withdrew in the course of the application before the judge the contention based on confidential information, the claimant puts his case squarely on fiduciary relationship. So the question before this court is, did Y, that's the second defendant, the English company, and I'm going to rather labour the terms because even if the court understands all the abbreviations, I'm going to get them wrong, owe a fiduciary obligation to the claimant A. And if so, that duty must be derived from the contract between A and X, the first defendant, the Singapore company. I'll come back to the two letters which make up the contract, which are in the core bundle. Let me come to that. But the first point, I was going to first of all to deal with these questions of fiduciary obligation and some of the authorities on experts. The judge, if the court would turn to the judgment, the anonymised judgment, which is at Core Tab 7. So, leaving aside the difference for present purposes, which we need to come back to between X and Y, the finding of fiduciary obligation comes in paragraph 53, page tab 7, page 97 of Core. So she starts off with a negative proposition, that none of the authorities supports the proposition an independent expert does not owe a fiduciary obligation of loyalty. The circumstances in which an expert is retained to provide litigation or arbitration support services could give rise to a relationship of trust and confidence. So it's trust and confidence that she relies upon. In common with counsel and solicitors, just pausing there a moment, and counsel and solicitors are rather different. The court, of course, is not remotely concerned with what counsel's opinion is, which is inadmissible and irrelevant. The court is concerned with counsel's submissions, which is not, of course, the position of an expert. An independent expert owes duties to the court that may not align with the interests of the client. And then the judge says the paramount duty is not inconsistent with an additional duty of loyalty. See Jones and Caney, says the judge. That's the paragraph where she finds that there is a fiduciary obligation. It is true that the question whether there is trust and confidence is part of what gives rise to a fiduciary obligation relationship, but there is more to it than that in our submission. Just a reference in my skeleton is paragraph 31 onwards. My skeleton, I think, starts at page 40 of Core, and the section starts at page 48. And because I've cited the passages for this purpose in some detail, I can take it fairly shortly. I just want to show your lordships the principal authority referred to, which is Lord Justice Leggett, which is at 118. And as I said, I'll take it quite quickly because I've referred to it in my skeleton.
Yeah.
So if the court could look at authority as 118.
Yes.
And many of the recent joint cases on fiduciary obligations as to whether one is owed or not relate to joint ventures, where sometimes they are and sometimes they aren't, depending on the circumstances. The passage starts at 157. This is a joint venture case, and I've set out the passages, but I think there's 3 points I want to make from this authority, Lord Justice Leggett. At 157,
Yeah.
it is exceptional for fiduciary duties to arise other than in certain settled categories of relationship, paradigm case, trustee and beneficiary of a trust, other settled categories, partners, company directors, solicitors and agents, and so forth. So this is not one of... the starting point is it's exceptional to find it outside established categories. 158 and 159, perhaps the best reference to the circumstances when a fiduciary obligation arises, on top of 159, top of the next page, typically arise where one person undertakes and is entrusted with authority to manage property or affairs of another and make discretionary decisions on behalf of that person. And then a couple of lines later refers to where the advisor has a substantial degree of power over the other party's decision making. And so that doesn't apply here either. And then at 163 and 164, Lord Justice Leggett, 163 refers to the argument that there was a close personal relationship. In the fourth line of 163, the existence of trust and confidence is not sufficient by itself to give rise to fiduciary obligations. And then he refers to the fact that trust and confidence often, for example, arises in commercial relationships. That's 164. And then at 165, I think is perhaps the point again about mutual trust and confidence. And again, the second half of that paragraph, founded on the acceptance by one party of a role which requires exercising judgment and making discretionary decisions on behalf of another, and constitutes trust and confidence and the loyalty to put aside his or her own interests and act solely in the interests of the principal. So those are the points that I just wanted to emphasise from that authority. The other authority on fiduciaries, there's only really one paragraph that I wanted to draw attention to, and that is set out in my skeleton, so perhaps we needn't go to Glenn and Watson in the underlying authority. That is in paragraph 32 of my skeleton. The paragraph is set out. And the reads page 49 of the core bundle. And the reason I wanted to show the court that is because it's the passage about 2/3 of the way into the citation. There's a line starting being appointed, about 8 lines from the end. In each case, however, if the court has that, the nature of the relationship is such that B can expect A, in colloquial language, to be on his side. Now, that's why the distinguishing obligation is that of loyalty. Someone who's agreed to act in the interests of another has to put the interests of that other first. It means he mustn't make. Anyway, so those are the two those are two authorities I wanted to show the court on fiduciaries generally. In our submission, it is hard to think of any expression so inappropriate for a litigation expert, and the court may not want it to be commonly thought that this was a fair description of a litigation expert. In our skeleton, we refer to the efforts of the courts to change the climate of litigation experts, which have percolated into other proceedings in other jurisdictions, from access to justice. I'm not going to refer to that because it'd be well known to the court, but the climate has changed since 1999 and the CPR in relation to litigation experts. The court will be well aware of those matters, and in our submission, wholly inconsistent with describing it as a fiduciary obligation. So, the next point I want to make, we refer in our skeleton to a number of cases on recusing litigation experts. This is the section of my skeleton, paragraphs 34 to 40. These cases are not directly on point.
Sorry, this is paragraphs
34 to 40.
34 to 40
and we
of your
set out a
skeleton.
number of cases, that
Yeah.
very few of which I'm going to take you to.
So you say these cases are not directly important?
They're not directly, none of them answer the question before this court.
Yeah.
However, they are relevant. Firstly, they're referred to by the judge, and secondly, the way the courts have treated litigation experts is a relevant backcloth to the point in issue.
So your heading for this was what? Did you say?
Was
Refute.
case law on recusing litigation experts.
Recusing. That was the word I missed. Recusing
Sorry.
litigation. No, it's fine. Recusing litigation experts was your heading. And then it's
and
34 to 40.
It's 34 to 40, and
Yeah.
I'm going to, rather than take, I'm going to take you to one or two of them, but in general, rather than take you to a lot of these cases, I'm going to summarise, if I may, what I see as the principles.
Yeah.
These are cases where the court has been faced with arguments that the expert, whether a litigation expert or advising in litigation, should not be recused. They are mostly based on attempts to apply the Baccaia test to expert confidential information, and the vast majority of them are confidential information cases. And under this category, Harmony Shipping, Meat Corporation, and A. Lloyd Syndicate versus X. And if I can summarise what I think they are authority for, first of all, the courts have declined...
Sorry, Meat Corporation, that was.
Meat Corporation,
Yes.
I'm so sorry.
No, that's fine. Thank you. Yes.
It's Justice Mann's case.
Yeah. So Harmony, Meat, and Lloyd's.
A. Lloyd Syndicate
Syndicate,
versus
yeah.
X.
Yeah.
The courts have declined to employ the Baccaia test in this area. First point. Secondly, they've stressed the special position of experts. Thirdly, they've made it clear that merely because an expert has had confidential information is not of itself a reason to stand him down, to recuse him. Fourthly, the courts have in mind the desire that the court should hear all relevant evidence. And fifthly, in none of these cases has anyone suggested that the expert is or might be a fiduciary. Now, there's only one of them I wanted to show you, and that is my Lord Justice Coulson's case, which I should have referred to in my skeleton, but I didn't. But perhaps we could just look at that briefly, because it makes one point, which is Wheeldon Brothers. Now, this was an addition to the authorities bundle.
I think it was on. It was on the
should be
bench.
a bundle 232.
Well, not to worry. I mean, I've got a copy because I noticed it on the bench.
Yes.
I'm glad you weren't suggesting I was in any of the cases you just reeled off, because even I couldn't remember that. Yes, fine. Wheel.
Just to give so
Yes, I'm not sure I've got it.
we can provide.
Maybe, my lord, it's found your way into the authorities bundle at tab 32.
That's where I thought it was.
Not into mine.
Not into the law. I'm sorry about that.
Yeah, I've got a spare copy.
We have a spare copy.
That's very kind. Thank you very much.
Just in summary, what happened there was that the defendant instructed an expert after a fire. It was thought originally that there was no issue between the claimant and defendant about the insurance policy, the defendant and insurers, and the claimant said, can we use your expert to assist in our inquiries in relation to a claim against third parties? Defendants say yes. It then turns out unexpectedly there is an issue between the claimant and the defendant, and the claimant seeks to injunct the defendant from using the expert. Well, not a particularly attractive claim, perhaps. But the passage that was refused, see paragraph, and I just wanted to show the short passages. There's one particular point I wanted to draw attention to. 13 on page 237. The reference in paragraph 12 to Dawn Meats is what I call Meat Corporation, by the way.
Yes.
13, Mr. Brown is the best possible position to assist the court on many of the background issues. He attended immediately after the fire, carried out the usual and extensive investigations typical of fire experts in this situation. Nobody else did that. Best person to address those issues. So that's absurd if he was prevented from providing necessary assistance on those issues to the court. That's the first point. 15, I don't see any overlap or conflict. So
Sorry, why does that help on the facts here?
I'm just showing the basis of the decision. It was the passage that I wanted in particular is about 16. Is 16.
So far, 13 is concerned with essentially factual evidence.
Yes, I'm sorry. 13.
Yeah,
13
I'm not
and 15
saying.
are, yeah.
I understand where you're going. I'm just
Yeah.
seeing this for the first time and trying to understand it as we go along.
Yes, I'm sorry. I'm perhaps taking it a bit fast. 16 is the point I just wanted to show, that this is a case about instructing an expert pursuant to CPR Article Part 35. As is well known, an expert instructed under that rule has an overriding duty to the court. See Carr and Reefer. That duty trumps everything else. It was not a factor that was present in Prince Geoffrey, because that wasn't a case about expert evidence, but it was a factor relevant to the outcome in Dawn Meats. In my view, the existence of that overriding duty also modifies the strict application of the rule in Prince Geoffrey. So that was really the reason I wanted to show the court. 17, it was said that actually no confidential. There's a question of confidential information. In Dawn Meats, there was confidential information, but no risk to be passed on. This case is even more clear-cut. No evidence that confidential information was passed to Mr. Brown in the first place, and no risk to be passed on to the defendant. So, I mean, the whole series of reasons for the decision. It was the point in 16. It's the emphasis, which I think one sees from other cases, but that was really the reason why I wanted to show the court that particular authority. So that's one set of cases.
But you don't disagree with Jones and Caney and Lord Phillips's comments that the two can coexist?
Okay.
Yes.
Yes. I think we refer to it in paragraph 60 of our skeleton, the passage from Lord Phillips. Now, the other line of cases on whether to recuse experts from giving evidence, which are referred to in our skeleton at paragraph 37, is it? 37 onwards. These are a bit different. These are an expert has been appointed and the court is considering whether to allow the expert to give evidence in view. And when they talk about conflict here, they are often talking about a quite different type of conflict. So, for example, I'm not sure we need to turn this up. Toth and Jarman, which I referred to in the skeleton. All I think that's relevant on that is paragraph 99, where the Court of Appeal said that there was an argument about conflict of interest in the form of the expert's membership of the Cases Committee of the Medical Defence Unit. I don't think we need to turn it up, but that's a different sort of conflict. The expert might be member of a committee or something of that nature, and there's a line of cases on essentially what they say is that a conflict is not a necessary reason. Merely because there's some form of conflict doesn't necessarily mean the court won't have won't hear the expert give evidence. So
it's a paragraph 100, isn't it, of Toth, which just says it doesn't automatically disqualify.
Exactly so. So I don't think I need to go to that line of cases, but that's what they're concerned with. There are, so far as I have been able to ascertain, only two cases where there has been none in this jurisdiction where there's been any suggestion of a fiduciary relationship. The first one, which I referred to in the skeleton at paragraph 35, isn't really on reflection on point. It's an Australian case called Wimmera, and the reason why it isn't really helpful, I think, is that the fiduciary argument's the wrong way around. Here was somebody who was involved in the invention of a patent, and it was argued that he couldn't thereafter be an expert in litigation about the patent because of the fiduciary obligation he had in being a co-inventor. So it's the wrong way around in a sense. In fact, the court said he didn't have a fiduciary obligation in his capacity as an inventor. So, but I've referred to that, but I suspect on reflection it doesn't help. The only one where actually there is a recent reference is a case that I didn't refer to it in my skeleton because I wasn't aware of it at the time. It is an Irish Court of Appeal case this year. And again, it's only of significance because it does refer to the suggestion as to whether the individual is a fiduciary.
So this is Sweeney.
This is Sweeney. I noted, this is bundle 2, tab 23. I noted with alarm that the copy says at the top, unapproved. That is the copy on Bailey.
Right.
So Bailey seemed to have, if the court is concerned about that, we will provide hereafter a copy without that wording on it. But because it's on Bailey, I hope that will not be a problem.
Does a copy without that wording on it exist?
Yes,
It does.
I think we found. I think we found it subsequently when I saw the unapproved. I was going to hand it. I was going to provide it, but
Things we all know do get onto Bailey.
I'll make available afterwards a copy without that. You can see what the case is about in paragraph 5. Professor McDowell was retained as an independent economic expert. He was a lecturer in economics, acted as an economic expert in witness in many actions for the Irish courts, including a significant number of competition law claims. This was a competition claim. The essential base of the objection, which forms the base of the application, is the professor was and continues to be retained by the defendants as an economic expert in 2 other competition cases brought against them, arising from decisions made by it not to provide PHI cover to other private hospitals elsewhere in the state. Now, the basis of the decision is confidential information. In other words, so it's not directly on point, but there's a passage I'll show you in a moment about fiduciaries. At 98, so that's page 56 of the authority, A879, it appears to me that the essence of the complaint here is that the professor ought not to be permitted to act as expert in these proceedings, not because of his ongoing retainer in the other proceedings per se, but because of the privileged and confidential information he's been provided to him by VHI for the purposes of that retainer, and the risk that such information could be disclosed in these proceedings. So that's and then the decision you can see at 111, page 62 of 72. Having referred to a number of cases, including Wielden Brothers, for what it's worth, 111, the facts are, in my view, significantly different to those cases, and that's the uncontested evidence of Quigley is to the effect that the professor obtained significant insight into the operations of VHI, highly sensitive, privileged, confidential material related to the proceedings and their defence, was provided to him in connection with each of those proceedings. As I've sought to explain, an economic expert in a competition law action is a paradigm example of a category of expert witness whose retainer necessitates the sharing of significant levels of confidential or privileged information, and who's likely to have a significant involvement in strategic decision-making in the litigation. Materially closer to Bacaya than Meat Corporation, Aloyd Syndicate, or Wielden Brothers. So it was a confidential information decision. The bit I wanted to show you about fiduciaries at 96,
So I hadn't got to the end. The result was
He was disqualified on the basis of...
on the basis of effectively of what's said at 111 and onwards.
Exactly.
Yeah.
And the passage which has some relevance, because it's the only authority I found where this point is ever discussed, is at 96.
Someone who has a significant involvement in strategic decision making in the litigation, even if he is also giving independent expert evidence, is at least in one sense on their side, isn't he?
Well, the difficulty with being on their side is that if he's actually giving evidence, the starting point is his opinions. Unlike the position, say, of counsel, who makes submissions, and as I've said, nobody's interested in counsel's opinion. Where you're having the expert, the starting point is what expert is the expert going to give as to his opinion.
Well, of course, when he's actually in the witness box and preparing his report, but isn't the reality that when an expert is engaged to give evidence, his role is going to straddle both aspects, both independent evidence and input into the conduct of the litigation.
But the premise of that is that I'm going to be giving evidence saying X, Y, Z, and therefore anything which is inconsistent with that. I mean, that's the starting point, which is different from, for example, the counsel and solicitor, where there is no, the only starting point there is one's duty to the court not to mislead and so forth. Where you're having an expert who is actually giving evidence about particular matters, in that situation, that inevitably will restrict his role beyond that. If you look at 96, which is the reference to fiduciary, the plaintiffs submit, this is page 55, that a fiduciary relationship doesn't exist between an expert and a client. VHI doesn't in fact contend there is such a relationship. It may be the relationship between client and expert witness has certain characteristics of such a relationship. It would be surprising if an expert witness could properly use information provided to them to make a secret profit. But any finding the relationship between an expert witness and principal is fiduciary in character would have far-reaching implications. It would put an expert witness in an impossible position, torn between their fiduciary obligations to their principal and their overriding duties to the court. That point is made by the plaintiffs, and in my opinion, it is a compelling one. It would also mean that expert witnesses would be excluded from acting against their principals, even if the two mandates are unrelated. However, the VHI expressly disavows any contention that experts are, by reason only of a prior and ongoing engagement by a client, excluded from acting as expert against that client, even on an unrelated matter. I'm not sure that would follow as a matter of English law.
No, that's with great respect, that's an odd paragraph, isn't it?
It's certainly not English law, I suspect, if I may say so, it isn't Irish law either. Procedural is a very controversial Supreme Court of Canada decision, which follows the North American line that you can't have conflicts on even on unrelated matters, which has never been the law in this jurisdiction.
And nobody in this court would say that if there was, whether it's confidentiality or conflict, would say that if there were wholly unrelated matters, there would be a relevant conflict or bar. Nobody's suggesting that.
Your ladyship's absolutely right. So I refer to 97 because it's on the usual point, but I don't think 97 is right. If it's right at all, it's not right as a matter of English law. So those were the authorities that I wanted to show you on, and that's the only one I've found anywhere where the suggestion has been made that an expert could be a fiduciary.
Well, I think that my understanding is, notwithstanding the diligence of both of you, that is the position, that those are the two cases in which it is referred to, albeit, as you properly say, tangentially, and other than that, it's not expressly addressed, except now by Mrs. Justice O'Farrell in this case.
Yes, I think one could say that some of the expert cases, such as X Corporation, what if it could have been if if the point was right, it could have been argued in those cases and never seemed to occur to anyone. But that obviously only takes the point so far.
But the point is, forgive me, the point is taken in Akai, where you pick up, don't you, some of the flavour of paragraph 96 of this judgment, which talks about the relationship has certain characteristics of such a relationship. And then in Akai, you get the court saying, as a result of the contractual retainer, the expert having duties akin to those of a fiduciary. So it's not a fiduciary in the strict sense, but depending on the terms of the retainer,
Yes.
a relevant duties are being created.
Certainly, the retainer may create certain additional duties. I mean, there may come a point, and this is not a point really that this court is concerned with, where it could be said that the obligation in the contract is unenforceable as being contrary to public policy. But I mean, that would be an extreme case. One thinks about, I mean, there was a suggestion of that by Lord Denning in the Harmony Shipping case, but I don't think that needs to concern the court for present purposes. One can see that would be an extreme case, but it certainly has some of the characteristics. I would accept that. So the next point,
But when, just looking at paragraph 96 of Sweeney,
yep.
It refers to the possibility of an expert making a secret profit.
Yeah.
Saying obviously that wouldn't do. But when you actually look at some of the secret profit cases about fiduciaries, they say that the term fiduciary is being used in a very loose sense. So you have, for example, I think a vet in one case, or a sergeant in the army in another case. Is that something which might be relevant here, treating an expert as a fiduciary, not really a fiduciary, but using that term in a very loose sense?
Well, I think the question is, what are the duties of an expert, and what are the obligations? Your Lordship may be right in the sense that there are some of the characteristics, but I mean the main characteristic of a fiduciary is one of loyalty, and that's what is being referred to generally, and that's what gives rise to the special rule in terms of conflicts, is the obligation of loyalty. And that, when one thinks about the expert who prepares a report, then meets with his opposite number and realises that he's made a complete mess of it and has got it wrong, his obligation is to change his report. His obligation isn't to take his client's side and argue for his case. I mean, that in a sense is inconsistent with the basic obligation of loyalty. It's very hard to see how that can stand.
Yeah, I understand that.
Well, in this case, the real issue is nothing to do with either secret profits or loyalty as such. It's to do with conflicts of interest.
It's a duty of no conflict. And what if the obligation doesn't arise out of the contract, but is in the contract?
That's the next point I was going to come to, relation to it. So the agreement, the agreement, core 14 and 15 are the two documents, and you've anticipated the point. So there are only, I think, two matters to refer to here. One is the scope of work, so it's tab 14, page 139. And
so we're at tab 15.
well, there's two letters. There's 14 and tab 14 and tab 15.
Oh, sorry.
139.
Yeah, sorry, of course. 14 is the first letter. And is this right, as on a small point of fact, there was already by this stage a confidentiality agreement?
Yes, there was. It's in the supplemental bundle.
Right, okay. So somewhat unusually, possibly, the confidentiality agreement came first.
Yes. Find you the reference. No. Oh, is it? I'm sorry, my fault. It's in the same tab in the core bundle, 143.
143. Yeah, so that's March.
Yep. So these are both May 13th and 26th.
Yeah.
There are just two matters that one needs to focus on in respect of this. The first is the scope of works, and the scope of works are set out bottom of page 139, and they are repeated at 146 in the second letter. What they comprise, I think the point to make in respect of them is they are all part of matters ancillary to giving expert evidence.
There is a slight difference in that the second letter says, in the first instance, your scope of work shall consist of, which might suggest that it is potentially going to expand.
Well, it might be a request, but yes. So that's good. But I think the point to make is that they're all ancillary. None of them are analyse what's wrong with, analyse how to make sure we don't get into a similar mess again with our business. For example, there's nothing like that which goes outside the ancillary to. And the other point is, of course, the conflicts of interest clause at page 140, which is the confirmation you have no conflict of interest. So, as my lady puts the point, the next question is what that means.
Well, it's the second sentence, isn't it?
Yes. So the first point to make in respect is to look at the context in which this is agreed, because what comes before it is Supplemental Bundle 104. Perhaps I can just ask the court briefly to read this from the bottom email up to the top one. 104. So that is what is being asked, and when confirmation is being given, it is effectively a rather formal matter. In other words, in my submission, is there any conflict reason why you shouldn't act as an independent expert? So there
What state of facts would require the answer yes?
Well, I think that there are different types of. If the expert himself is acting in, I mean, all he's being told is the parties, and being given quite limited information. I mean, there's one type of conflict which is what I call the Toff and Jarman type conflict, which is I am sitting on this committee which is inconsistent with. There's another type of conflict which is where I am acting on the other side. But I mean, it's that sort of conflict. I think the point I'm seeking to make with respect to that is that it is built up by my learned friend in his submissions as this is a clause which in some way adds to the position already.
So if he's acting for the named claimant, he's got to say there's a conflict.
That's certainly what is envisaged from this letter.
And if anybody in his firm is acting for the named claimant, what then?
Well, I think one the position becomes somewhat more debatable at that stage. If his firm is acting for if it's in the same arbitration, then I think that's what is envisaged there.
Yeah, well, I can quite see there might need to be an answer where you need to tell me a little bit more about what project this relates to, which indeed is what he says at the top of the page.
Yeah.
But if it turns out that it is the same project and somebody in his firm has already been instructed to act for the other
But in the
party,
same arbitration, certainly.
okay, so you limit it to that.
Well, I'm not sure. I think in a sense it begs the question in relation to exactly what is meant by a no conflict. My submission in respect of this clause is it doesn't go beyond what the position would otherwise be at law. The
Sorry, it's my fault. What do you mean by would otherwise be at law? What
well, I think
law?
what's being suggested is that this clause adds to the obligations and imposes some additional obligation in addition to that which would arise in any event. And my submission is when you look at it in context and the terms of it, it doesn't do that. So one simply begs the question as to where you have no confidential information as to why there should not, in any event, be why should it act in any event. I mean, obviously this is
Surely, I may have misunderstood or not read properly, but surely the starting point has to be the contract.
yes, I agree.
So I don't know whether you say Mr. Stewart says starts with fiduciary and just says the contract is an add-on. Surely he can correct me if I've misunderstood, but surely the starting point must be the contract.
I completely agree. However, the point I'm seeking to make, any obligation that then a friend is entitled to rely upon has to come from this contract. I completely agree with that. There would be, where one is acting as a litigation expert in an arbitration, certain circumstances where one could not act in any event, even if this clause was missing. So, I mean,
Because the expert rules applying to the arbitral process.
because the expert rules apply,
Right.
and I don't think anyone suggested that there's any real difference. So and I mean whether the Irish Court of Appeal case is correctly decided or not doesn't really matter. One can see that sort of factual position where the expert is acting on both sides. But in general, the cases have not in this jurisdiction gone beyond a confidential information issue. Now, obviously, there's the separate point about the different company, but I'm not on that for the moment. My submission is this clause does not increase the burden. And Leonard Friend, I think, seeks to say that a fiduciary obligation is imposed as a result of this clause. Now, so my submission is you could take away this clause and the position would not be any different. And the reason,
Suppose it's not a fiduciary relationship.
yes,
In other words, suppose we accept your submission about that, and suppose there's no problem about confidential information.
yes,
For example, because you could put up a successful information barrier.
yes.
And you say the clause doesn't go beyond what's the position at law, but in those circumstances, what are the duties at law and where do they come from?
Well, they don't in general. They have not gone beyond confidential information,
Right.
unless there is a clause. There's no authority, and we can look at Akai in due course. But there's no authority which goes beyond confidential information, unless there is a clause which expressly restricts it. I mean, Akai is a case. I don't know. You may or may not have had a
Yes,
chance to see it.
I've looked at that.
But I mean, that's a case of a wide-ranging clause.
I thought it was very similar. Was it much broader, is it?
Oh, yes.
Okay.
I'll show you.
Yeah, of course, no.
Yeah.
Take your own time.
So does this mean that if you don't have any express contractual clause, which might inhibit you, if you do have an information barrier, so there's no problem with confidential information, why can't you have two experts from the same firm acting
No.
for opposing parties in an arbitration?
No reason in principle. You
Sure
should.
you can. Okay.
I mean, as your lordship knows, I mean, I don't need to go that far because there's the separate company point, which I'll come on to in due course. But even if it was the same company, then my submission that the barrier is a confidential information barrier rather than anything that goes beyond that. So just in terms of this clause, my Lord Justice Mail said, well, assume for a moment that we accept your submission that an expert is not a fiduciary. In a sense, if you were to find that an expert was a fiduciary or effectively a fiduciary, this clause probably doesn't matter. So one has to hypothesize, therefore, that the court takes the view that an expert is not a fiduciary. So what does this add? If it would mean that you've rejected that submission, does it change the character of the relationship? So the expert who is not in any normal circumstances a fiduciary and whose obligations are in any normal case inconsistent with being a fiduciary does this change the entire relationship? So the expert now owes a quite different set of duties. In my submission, it plainly doesn't do that. The wording, I've shown you, Lordship, that the wording reflects previous correspondence. This is not what might be described as an interesting clause, or it doesn't purport to create obligations or impose a new duty. It doesn't suggest, there's nothing unexpected, if I can put it that way, about it. The wording is not apt to create some form of new duty that is already there. And if the courts...
It's very simple. It just means we confirm there's no conflict now, and we promise that there won't be a conflict in the future.
Yes.
Clear undertaking.
Yes, I agree.
So I mean, it doesn't need to be complex or interesting, does it? It's clear on its face.
But well, it's clear. Then, but I mean, does it add to what the position would be already? In my submission, it doesn't.
I think what you mean when you say it's not interesting is something like, see if I've understood this correctly, it doesn't say you're now a fiduciary.
It doesn't say you're now a fiduciary.
Is that essentially the point you're making?
Or any words which would have that effect. I mean, maybe we should maybe it might be helpful to look at the Akai case, and in the light of the reference to it, I'm not sure where your lordships have, where the court has that.
Right at the back of the second.
Is it at the back of the second?
It was sent up with our supplementary note yesterday,
Yes.
my lord.
Yes.
If you... So what had happened here, Akai had major litigation against Ernst & Young. Akai had instructed Robson Rhodes, and Ernst & Young had instructed Grant Thornton. And Robson Rhodes and Grant Thornton were planning to merge. So Robson Rhodes say, we will act for either neither party or both. If we act for both, we won't do that without consent. That consent wasn't available. Akai said, if you stop acting for us, Robson Rhodes, you will be in breach of the retainer. You can't do it. And you will be doing it to prefer your own interests, i.e. in smoothing out the problems, to our interests. That was essentially what they said. If you look at paragraph 4, we see the clause. There are two parts of the clause because it was amended. And we see that there's a wide-ranging clause in clause 17, where an actual or potential conflict between your interests and the interests of another of our clients may arise during the course of the provision of services. Decide what to do. And then there is a further provision over the page, which was amended. We confirm we've undertaken appropriate searches, not aware of any conflicts that will prevent us from undertaking this assignment. Notwithstanding clause 17, we will not undertake any act or enter into any engagement that would or might put us in a position of actual or perceived conflict. So that was the clause.
Which is the same, isn't it? Isn't it? There is no conflict, and we promise that there won't be a conflict in the future. This is wordier, I grant you.
Actual or potential conflict, this is the first part, between your interests and the interests of another of our clients. And I think that is wider.
But those extensions aren't relevant on the facts here, are they?
Well, I think, I mean, this is
because we're not arguing about potential conflict, we're arguing about actual conflict.
Well, if you look at actual perceived conflict on the second clause over the page, last part of that, actual or which would or might put us in a position of actual or perceived conflict, and it was determined. There was no dispute that the experts themselves would continue to act. Look at paragraph 15. Fourth line. principal expert witnesses themselves, line 31, i.e. Mr. Atwood and Mr. Lawrence would continue, but both having no connection with the merged firm, and the support teams would be withdrawn on both sides. And I think the judge recognises that that's common ground at paragraph 22, line 23. To 26 wouldn't mean that either of them would lose their... So the witnesses would still give evidence, but the support teams and the ancillary backup service of the respective firms would not continue. I think Mr. Lawrence, acting for, who worked with Grant Thornton, was not actually part of Grant Thornton. See, if you look at paragraph 5, he appears not, if you look at the end of paragraph 5, Grant Thornton appeared to be providing backup, but Mr. Lawrence wasn't connected with Grant Thornton, whereas I think Mr. Atwood of Robson Roads, who was a consultant, see paragraph 3. So for the expert, it seems to be envisaged the experts would continue, and the issue was not about the experts, but the backup services, as to whether Grant Thornton and Robson Roads should do that. There was no suggestion of a fiduciary relationship, and the decision seems to be in 45 and 46. I think what is argued by Mr. Malik for the firm is that there was no reasonable prospect of showing that a merger... The point I think he was making was that if you look at the clause, it's about a conflict between two clients and not an own interest conflict, such because it was said that actually what Robson Roads were doing were preferring their own interests to the interests of their clients. I think that's the point he was making. Bottom of paragraph 45. So he says it's only about conflict from double employment, not about conflict between interest and duty, and submits that by ceasing to act. And that seems to be the only argument that was raised in relation to the clause, which perhaps wasn't surprisingly rejected in paragraph 46 by the judge. And he says in 46, line 6 on the page, it's true that clause 17 is faced with double employment conflict. By drawing attention to the risk of it arising and setting out a procedure for dealing with it, it assumes the conflict between two clients arises after Robson Roads has begun acting for both. It doesn't permit them to accept a retainer from a client whose interests already conflict with those of an existing client. But the fact it's silent about conflict of interest and duty doesn't mean the duty to avoid that type of conflict isn't to be implied in the retainer. One might have thought that was not a terribly attractive argument to be raised by one raised by Mr. Malik. That seems to be the only argument that was raised in relation to that clause, and the judge concludes that he grants an injunction on certain undertakings. And there's quite a lot of the judgment is dealing with provisions about grant of an injunction. So it is a much more wide-ranging clause in my submission, and certainly treated as such. It appeared to be accepted that certainly prevented the use of the backup teams, and subject to the argument in paragraphs 45 and 46. So that's the Akai case. I'm not sure with respect exactly what it is authority for. I don't accept that it's a clause anything like the present, but it doesn't seem to have been, certainly not suggested as a fiduciary obligation, and it doesn't seem to have been suggested that, I think maybe because there wasn't an issue about the experts themselves. So that's Akai. The other point made by my learned friend on the contractual provisions is that the expert does things other than give expert evidence. It's a point my Lord Justice Mayles mentioned earlier. We looked at the list of items in the contract. These are not matters that go outside being ancillary to expert evidence, the point I've made already. And the starting point is that the expert will give the court an independent, objective view. And in a sense, the assistance he's going to give assumes as a backcloth that the opinion which he's going to give in court. And it's quite different from really some separate retainer which is outside that. So I think those are the points I wanted to make on...
Just on that point.
Yep.
Obviously one always has to be careful about one's experience and so on, but this is a delay expert.
Yes.
I am on record as expressing scepticism in various past cases about whether there's such a thing as a delay expert.
Yes.
It's rare that actually there's any form of expertise involved. Sometimes there can be a programming issue, but more often than not, there isn't. And the purpose of delay experts is to sift through sometimes the voluminous material on a large project and try and work out what the particular or critical delays might be and who might be responsible for them. And so, a bit like an accountant in some commercial disputes, they're more of a collator and focuser of the material rather than anything else. And the reason for just interjecting with that at this stage is that certainly in my experience, it goes it a bit to say that a delay expert is somebody involved throughout with the focus on their report, because of the collating role that an expert does. That isn't my experience. Now, I don't know the extent to which that may matter. It may not matter at all, but I find that concept quite difficult to accept, because in my experience it is generally the other way, that an expert dealing with delay is involved throughout on I think what's referred to somewhere else as a roving basis.
Well, Your Lordship, I think, has more experience in construction disputes than anybody else in this court.
A lot of that was a long time ago.
Well, the point I make in respect of that is that still, whatever sort of expertise, the starting point is the duty to the court or tribunal to give your opinion and to give your honest and objective opinion. And whether that is matters, and that may involve, for example, referring to documents that are contrary in a way that, taking points against your client in a way that persons who owe fiduciary obligations, such as lawyers, would not be obliged to do, subject to obviously to the obligation not to mislead. It's still a different role, and it's a fundamentally different role because of the nature of, and one can see why. And again, the one case on the facts, although not in a material way, which goes a different way, is this Irish case, where the court says, well, you've had so much, you, the individual, have had so much confidential and privileged material that actually you can't act on the other side in respect of this. And that's based on the confidential and privileged material, and you can see that. And you can see that in one or two of the expert cases where and I think, Your Lordship's case, Wilden, where actually if you look at what the expert was doing in his two different capacities, they don't overlap at all. You can see this distinction can be drawn. But it doesn't change the fundamental issue. One's talking not about confidential information, but an obligation which goes beyond that the starting point is the obligation of the expert to give his objective opinion on whatever area he's doing.
What about an expert who is instructed, among other things, to help to promulgate disclosure requests? Isn't the expectation there that he will be identifying documents which the other side may have, which are likely to support the case of the party instructing him? And in making those, or in providing his input, he's not expected, is he, to suggest that they ask for documents which will support the case of the opposing party.
But it's not a fundamentally different role to that of the expert. It's not where he's going way outside that and doing something entirely different. Which, I mean, he wouldn't have a fiduciary obligation in terms of because he identifies disclosure requests. That's not what a fiduciary does.
But that's all helping to support the case of the party instructing him. Just it's the kind of thing which a solicitor with experience in that field might do for themselves, or they might choose to enlist an expert's assistance.
It is, but that's not in itself going to give rise to a fiduciary obligation. That sort of obligation. Please have a look at the disclosure to date and tell us what helpful requests we could make. That is not an obligation which would give rise to a fiduciary obligation. There's no. In my submission, it would not come anywhere near the cases on fiduciaries as to what's involved in that. Your Lordship is right.
But he's not obliged, is he, in doing that, to put on his independent hat and say, well, my primary duty here is to root out the truth.
No, I see that. But they are all matters ancillary to giving expert evidence. And one can posit an example where he's doing something totally different, where he's giving evidence on the one hand, and he's also advising about how the business could be run in the light of the dispute, or something like that, where you can see he's doing something totally different. But here, it's all ancillary to his primary role. And it would not, if there was a specific thing he had been asked to do, which was within which could be described as a fiduciary obligation, that's one thing. But I mean, it would have to be something really quite a long way away. In my submission, this is nowhere near a fiduciary obligation. And the example your Lordship's posited really is not such an obligation at all. I think what your Lordship's putting to me is that he's not just giving expert evidence, he's doing things...
Well, I gave it as an example because it's one of the specific things that the expert in this case was told he'd be asked to do.
Yes, but that doesn't create a fiduciary obligation. I mean, beyond confidential information, there's no difficulty in him doing that, so long as he doesn't have access to confidential information, which he shouldn't have.
Well, I understand it doesn't create a fiduciary obligation, but does it not illustrate that he is performing, quite properly, something of a dual role?
Well, it goes beyond... I mean, inevitably, what he's doing goes beyond giving expert evidence, of course. And he's doing... But they're all matters which are ancillary to that. And one can no doubt think of other examples. And I take the point that he is going... That inevitably, on a complicated dispute, he's going beyond that. But he's not going beyond that in terms of a fiduciary. He doesn't... Why would there be any problem in him acting, so long as he has no confidential information, in somebody in his firm, for example, acting on the other side? I mean, I would suggest that was not something that arose from those sort of examples at all. Okay. The other, of course, the other point, of course, in this is that even if the court, whatever view the court takes on the fiduciary point, the duty has to be extended beyond from X to Y. So the question arises: how can Y owe the second defendant, the English company, owe the claimant a fiduciary duty because Y and C are strangers? So Y, the second defendant, English company, X, the first defendant, is a Singapore company, and the judge concluded that the fiduciary obligations were owed to the whole group. Now, if we can look at that in the judgment, which is tab 7.
I've forgotten who C is. Oh, you just mean the claimant?
Yeah. Sorry, if I call
Sorry, that's all right. You said
sorry.
you said Y and C are strangers.
I knew it would come a stage where I made a mess of the anonymisation.
Mr. Hollander, you've done brilliantly because it's an hour and 10 minutes in, and the claimant is variously A, the claimant, the respondent. I think you're forgiven for all of those different anonymisations. The only ones I can cling to are X, Y, and Z.
Well,
and so my heading for this part of your submissions is effectively extension from X to Y. And your point is, and you're going to show us the judgment, but your underlying point is, well, you say Y is a stranger to the claimant.
I mean, yeah, thank you, Will. I was quite proud of myself too, having got beyond the hour mark.
I've caught up now, I'm sorry.
The judgment at paragraph
54.
54. Yeah.
So, and just so you have the reference, we deal with this in paragraphs 42 to 51 of our skeleton. Now, so the judge at 54, page 97 at tab 7, makes the point that the first defendant was engaged to provide expert services for the claimant on first arbitration. First defendant was instructed to comply with the duties set out in the protocol as part of the engagement, also to provide advice and support for the claimant throughout the arbitration proceedings, and referred to the fiduciary of loyalty. And then she starts on the wider point, where a fiduciary of loyalty arises, it's not limited to the individual concerned. See, Bukaya extends to the firm or company and may extend to the wider group, Marks and Spencers and White and Case. Those are the three authorities she relies upon for that proposition. I'll come to those in a moment. First point to make is that she holds at 59 that the duty is owed by the whole of the defendant group. And the judge is correct to this extent, that she correctly recognises that if her analysis is correct, it must follow that the duty is owed by the entire group. There is no logic in some form of halfway house. And given that Y, the second defendant, and C are, and the claimant, A, are strangers, either the duty is only owed by X, the first defendant and contracting party, or logically it has to be owed by all the companies in the group. And if one just picks up for a moment the supplemental bundle at page 130, this apparently, I think the respondents put this in, this apparently is the group where I think there are 12 companies in the group, including one in UAE, Singapore, Hong Kong, Dubai, Toronto, Australia and Canada, New York, and so forth. Certainly so far as Y is concerned.
Well, I don't want to interrupt. This is actually from the appellant's evidence.
Oh, I'm sorry.
It's exhibited to Mr. Little's witness statement.
Thank you. So there are 12 companies. Y, the second defendant, is in a different jurisdiction. No suggestion of any contact at all with the claimant. So the judge then, so she refers to those three authorities in support of this proposition at paragraph 55.
Sorry, I have glanced at this organogram, but what I haven't done is just noted it up. So if I'm looking on the right-hand side, bottom column, the right-hand box, that's X.
Bottom right, yes.
Bottom right.
I'm pretty sure that's right.
I'm just going on the jurisdiction in which it's based.
Yes.
It's not quite the same name, but it looks as if it's the same company.
And if you look, so bottom right is X, first defendant. Next to it, on the just one further over on the left,
Is Y.
is Y, and Z is halfway up the left-hand side, referred to headquarters Atlanta.
Right. Thank you very much.
So the three authorities relied upon by the judge.
I mean, although Z is in the case, wouldn't make any difference if it wasn't.
No, the only point I make in respect to this is that the logic of it, that the point applying to all the companies in the group.
No, I see
or
that.
none.
Yes, yes.
But I mean, Z is of no materiality. Just firstly, she refers to a short passage in. So we see. The submission I'm going to make is that none of these authorities really have any relevance to this point at all. The first one she relies upon is Bacaya, which is tab 4 in bundle of 1 of the authorities. And she's referring to 234H, which is at the bottom of page, well, it's A117 in the bundle. Lord Millett, my lords, I would affirm this is the basis of the court's jurisdiction to intervene on behalf of a former client. That's the real risk of disclosure point. It's otherwise where the court's intervention is sought by an existing client, or a fiduciary cannot act at the same time, both for and against the same client, and his firm is in no better position. I think that's the passage he's referring to. A man cannot act without the consent of both clients act for one client, while his partner is acting for another in the opposite interest. So that's the conflict principle applicable to fiduciaries, but it doesn't deal with this point. The second one is Marks and Spencer's, which is tab 6 of the authorities bundle, first authorities bundle. This is a famous case, but it's an extempore judgment of the Court of Appeal in vacation, refusing leave to appeal.
Hot afternoon in August.
I'm sorry?
A hot afternoon in August.
It was June.
August?
June,
Oh.
June, but I'm sure it was hot anyway. I particularly like this case because of the last line on page 71.
Yeah.
But leaving that aside, Freshfields were injuncted from acting against Marks and Spencer's on a takeover. And the three passages, I think, which show what they essentially upheld Mr. Justice Lawrence Collins. Paragraph 19. So Freshfields had a number of continuing retainers for Marks and Spencer's, and then was sought to act on a takeover against Marks and Spencer's, or takeover of Marks and Spencer's. Paragraph 19. The submissions made to the present position of the applicants in relation to their clients, or, as it may be argued, former clients, Marks and Spencer's, in relation to the Davies arrangement. That's the big promotion, I think, which Freshfields were advising on for Marks and Spencer's. Mr. Brindle accepts the applicants have not resigned from their position as advisors on that matter to Marks and Spencer's. Hasn't come to an end. And then at 21, the first important finding of Mr. Justice Lawrence Collins, I'm satisfied there's a real or serious risk of conflict. The Davies contract, that's the one just referred to, is one of Marks and Spencer's most important contracts, except it is of considerable significance to Marks and Spencer. It will also form part of the deliberations undertaken by the consortium as part of their bid tactics, and it does seem likely that Freshfields will find themselves putting their name to a document which may well be critical of current Marks and Spencer's management and the Davies contractual arrangements, which will be in conflict with their duties to Marks and Spencer, particularly as I was told, although it's not in evidence, that steps could be made by Marks and Spencer to ensure the contract continues irrespective of the bid. And then 26, which is the other citation from Mr. Justice Lawrence Collins. So far as confidential information is concerned, it's obviously a huge amount of confidential information within Freshfields in relation to Marks and Spencer's affairs through acting for it over the years, some of which may be material to the bid, if only be discarded. I can't see, even with a firm the size of Freshfields, that effective information barriers can be put in place given the very large number of people involved, even on the two matters. There must be very many Freshfields people with knowledge of Marks and Spencer's confidential information in those circumstances. I'm satisfied that then referred to as Chinese walls cannot be or be seen to be sufficient. And I mean, those are essentially, the Court of Appeal refused leave to appeal from those findings. And I have to say, I can't find anything which supports the proposition the judge has made, that in some way supports the position. And the third one that she relies upon, which also doesn't assist really, is the George and Meadows and White and Case case, which is tab 14. This was a confidential information case. It was decided by Mr. Justice Field on the basis of confidential information and the fact that the information barriers were inadequate, as they were only set up a year after the problem arose. And you can see that at 87. Where Mr. Justice Field says, I conclude that White and Case have failed to discharge the evidential burden.
Sorry, which page are you on?
I'm so sorry. Paragraph 87.
I'm very sorry, I was looking at the page. So, paragraph 87.
Yep.
Right.
I conclude that White and Case have failed to discharge the evidential burden on them as to risk, and in consequence, I find there's a real risk. One, the confidential information in issue came into the possession of some of the Pinchuk team in the relevant period, and two, accordingly, use of that information, at least inadvertently, has been or will be made in the commercial court action. And then says, subject to delay, which he deals with, conclusion entitles the claimants to the relief they seek. So it's a confidential information case. And if you, I don't know why the judge referred to it. It may be because of paragraph 7. Where Mr. Justice Field said, that's page 331, that White and Case is a large international law firm comprising a number of different entities registered in the jurisdictions in which they operate. First defendant is a limited liability partnership registered in England and Wales. The second defendant is a limited liability partnership registered in the state of New York and now has offices in various other places. Now, it may be that's why she referred to it, but if it was, first of all, there was no argument in this matter that as to the difference between different entities. Second, and it's not discussed in the judgment, secondly, the point that the judge is making is that confidential information is travelling within the firm without protection. And given it's a confidential information case, if it's going between the various entities, then it doesn't, then that's a completely separate problem. And that both, I think both UK and US entities were involved in the work in different respects. It's not as though they're two completely separate matters, because there are references, for example, to discussions with the US General Counsel and the English. So I don't understand there'd be anything in this case which supports the proposition that a fiduciary or any other obligation can be owed under a contract to other than the contracting party. So those are the three authorities relied upon by the judge. So we then look to see how the judge deals with this, and just so the court has the reference to our skeleton, we deal with this at paragraphs 45 to 50. The judge deals with this at 56 and 57. So having made what we submit is a mistaken reference to those three cases in paragraph 55, she says the organisation is explained in the witness statement, illustrated by the organogram, and she makes the point as to the common ownership. And then 57, over the page, she says there is a common financial interest of different company in the defendants. Defendant group is managed and marketed as one global firm. There is a common approach to identification and management of any conflicts. So and that is the basis on which the judge, having held that a fiduciary duty is not limited at 55 to the, it may extend to the wider group, she holds that at 59, that perhaps I should just refer to 58 on the way. It was submitted that barristers are in this position with common funding, marketing, and interest in each other's success, but act on opposing sides in litigation, not apt to comparison. Barristers don't share profits and don't have a financial interest in the performance of their colleagues. Barristers are required to represent unpopular clients or causes, don't have the luxury of considering a case and deciding not to accept instructions because it doesn't fit their corporate image, although solicitors do. Thirdly, and perhaps most important in the context of this case, common knowledge that self-employed individuals working from sets of chambers and different barristers from a set of chambers may act on opposing sides. Defendants didn't inform the claimant they might take instructions to act both for and against the claimant in respect to the dispute, so they wouldn't have been instructed. And then in those circumstances, it's unrealistic to conclude that any duty of loyalty is limited to the first defendant. It is owed by the whole of the defendant group. Now, the point we make in our skeleton is there can be circumstances, in principle, where a non-contracting party owes a fiduciary duty to the other side. I think we gave the example of an SPV where a firm of solicitors are asked to set up a structure which includes setting up a vehicle company, an SPV. And you could see, at least maybe in some circumstances, where they might, although their client is the company that instructs them to do this, you could see there might be circumstances, for example, where they're held to owe a fiduciary obligation to the SPV as well, perhaps. And one can think of many examples of that nature. But what needs to be shown is the relationship between the company that is said to owe the obligation, in this case Y, the English company, and the claimant. Now, the claimant does not suggest that there is any relationship. They are complete strangers. And the judge doesn't suggest there's any relationship. Therefore, in our submission, there cannot be such a relationship. The judge is concerned about the fact that they're part of the same group, the fact that the group is marketed as part of a brand, and a common approach to conflict. Now, in our submission, that is just simply a wrong analysis. And what she's done is nothing short of piercing the corporate veil. So if there are 180 companies in the group, shall we say, then it would follow from her conclusion that all 180 of them, and in this case it's about 12, would owe a fiduciary obligation to the claimant. One can see the consequences of that because...
well, it's those companies or entities within the group which carry on the business of providing expert services in arbitration and litigation, isn't it?
Well, she doesn't suggest that. I mean, she says the whole group. There's no limitation on that. I mean, the trouble is once...
She probably does have in mind the facts of the case.
Well, I think because, well, it's the branding. It's the branding that she goes. And, I mean, so she says that in 59, the duty of loyalty, the whole of the defendant group have to be loyal to the claimant, and I suppose it would follow if that's the. I mean, it's not clear whether she's saying that they are effectively parties to the contract, because if one recognises, as one must, that the basis of the obligation comes from the contractual documentation, then how does that? She's effectively making the other companies in the group, whether all or those involving arbitration services, either she's making them as parties to that contract, or she's in some way saying that nevertheless the fiduciary obligation in some way has to extend. And we would suggest that simply is an analysis that can't be.
Why is that? If you accept the logic that a halfway house doesn't make any sense, which was what you started off by saying, and if you accept that, or if I put to you that clearly there is a contractual duty, there's an argument about what the contractual duty means, but let's assume it means something. Well, if there's no logic in a halfway house, why can't that be read as an undertaking which is given on behalf of all, either the whole group or all those parts of the group which are in the business of providing expert services and arbitrations? What's wrong with that?
It's just not what it says. Why on earth would one say? One would reach that conclusion? I mean, there's nothing in it which suggests that it goes beyond the individual company. There's no justification in the sense that it's a different company with different individuals with no confidential information issue. Why on earth would one want to extend it in that way? What business?
Well, so if somebody comes along who's going to pay higher fees, we can set up a separate company and call it whatever letter comes after Z, and act on the other side in the arbitration, because there's nothing here which says this is limited to X.
But there's no confidential information issue. So there's no. I mean, these are experts who are acting in arbitration. It's a different arbitration, and they are acting. There are different companies that are acting.
But if we took that to its logical conclusion, that would mean that you would say that Y could act as the experts for the subcontractors in arbitration 1.
Yes.
So that the experts would be X and Y. And
Yes.
you would say that's not a conflict of interest?
Not a conflict at all. I mean, it may be that the company, that the experts would not want that to be the case, would not wish to do that, but that's a matter for them. But there's nothing that could stop them doing that, because there's no obligation which is owed. I mean, otherwise one has to get to the stage where the whole group. I mean, what happened? I mean, the whole group is affected by this.
Well, that's why I put the other way to you, to try and explore what the limits were. It just as you say, there's no logical limit one way. There's no logical limit to your submission, which means that you can get to a position where X and Y could act as delay experts on either side in arbitration 1.
And so, again, why would that be, I ask rhetorically, why would that be a concern in circumstances where they are different individuals, they have no confidential information in common, their confidential information is protected, and they are strangers to each other, effectively.
Is there anything, you took us, and I'm still trying to work out what, if any, relevance / admissibility the document at 104 in the supplemental bundle has, which is the email surrounding the first letter, the first contractual letter. Is it of any relevance? And I may have got this wrong on the facts, that K is using a Y email address. So if I look at page 105,
Yes.
K is using a Y. Is that right? Is he?
I'm sure of the answer to that.
Do you see the point I'm
Yes, I do.
I'm getting at?
Yes.
It may be that there's another special.
Ladies, the evidence does disclose that there's a common email address across all of the emails, and they are in that form. There are no emails from any of the individual companies.
So that's the universal email, whatever you call it, tag for anybody in this group. Does that make a difference at all, Mr. Holland? If we're
I don't think it
contextualising
can,
this?
with respect. I mean, that's part of that. I mean, that's in the sense the judge's point about branding.
About branding.
Branding. It's branding. You can't make a difference as to the obligations.
So your submission anyway is that K would have been entitled to send that email exactly as it was, even if Y had already been instructed in the same arbitration on the other side.
But there would, so long as there is no confidential information issue.
Right.
And there will be some cases, of course, where there is a confidential information issue in respect to that. But if there is none, then one asks, well, why not? Why shouldn't there be it out. Maybe they don't want to. Maybe they wouldn't want to do it in the same arbitration. But in terms of could the court stop them doing that, we would submit plainly no.
So you construe conflicts as referring to confidential information, essentially.
Well, I do, but I don't. I don't need to succeed on that submission. I mean, I've given the example of conflicts such as, you know, the sitting on a committee, for example. There's that sort of conflict as well. The Toth and Jarman type conflict. So one may have that, but I don't need.
But it can't be that, can it? Because otherwise they'd need to be, in order for an answer to be given about that, they would need to have been given a bit more information about what the case was going to be about.
Well, I think the purpose of showing you 104 was to the exchange was to show you the context in which that confirmation is being provided, which is actually a very limited information confirmation. The alternative effectively would mean that if company A is acting as an expert, nobody in that same group, even though they've got no connection, when that is a fantastically broad proposition, particularly in circumstances where you have a small number of experts in a particular field. The idea that nobody...
We're not in that territory. Anybody who's been a quantity surveyor for 6 months regards themselves as a delay expert. I mean, I don't want to be overly sceptical, but I completely agree about the chilling effect on experts generally, and that doesn't detract from your point in any way. But again, I have to say that people fall over themselves to be appointed as delay experts. It's not a small number. But that doesn't detract from the wider.
I have a case at the moment where there's a large number of parties where it's been impossible to find experts who have the competence to act without actually using people from the same. Actually, in that case, it's the same company. Different experts with information barriers in the same company, because this just simply can't be done. But I mean, the effect of what's being said is that once one company in the group has entered into this retainer, then that in some way binds everybody else, and there's simply nothing in the wording of that conflict clause or the law which, in my submission, could lead to that result. There's no authority which would support it. In essence, what the judge is doing in our submission is she is piercing the corporate veil. He is effectively running together two companies with a separate existence, and so in a sense, it has to be read in the sense from learned friends be able to say that you have confirmed that you and all the companies in your group, there isn't a conflict of interest in the other companies, so I would suggest you have to read it. You have to confirm that you have no conflict of interest, and none of the companies in your group will act on any related matter or something of that nature. It's got to be wording of that nature. Otherwise, how does one know, for example, from that clause, that as to how it would affect other companies in the group? There's nothing in it which tells us or suggests that it covers anyone other. I mean, it's principally dealing with the individual who is the named expert. I appreciate it is addressed to the first defendants, but it's the person who is being engaged as an expert witness is the individual. And again, if you look equally at the letter that is at 146, again, he is the person who is going to be doing the job, and it is effectively addressed in substance to him. The obligations of an expert are all to him.
But the contract is with the company.
Exactly.
And if there's a breach, the claim would be against the company.
I completely agree.
I mean, you could say that cuts across actually what experts are all about, because it should be the individual. I think there are some cases about having companies as experts and whether actually that's appropriate. But anyway, that's how the world seems to work these days, and it's not, the contract is not with the individual, it is with the company.
I completely agree with that.
And as you would expect, if you look at the invoices, which were exhibited to the first indie evidence, you can see that there's a whole team of identified individuals working underneath K with entries for him being updated from time to time on their work.
Well, it is obviously the position that the backup services of the company will be used to assist the expert.
Yes.
No possible question about that. But there is nothing in that provision which suggests that the obligations go beyond that company that is referred to specifically and the individual who is going to be the expert. And if one wanted to stop other companies in the group where there was no confidential information issue, then in my submission, you cannot get that out of that wording. So that is the separate company point. Learned Friend in his respondent's notice, this is his skeleton 69 and 70, makes a new point which wasn't taken below. What he says is that the contract entered into is entered into with all the companies in the group. So as I understand what's being suggested, it's suggested that all 12 entities in the group are liable in contract. Presumably the effect of that would be that, if that was right, that the claimant could sue the Dubai company in Dubai on this contract somehow. In Dubai jurisdiction, there is no evidence to suggest that any of the other companies in the group authorised X to enter into the contract on their behalf, and there is no evidence that the claimant thought that this was on behalf of all the companies in the group. There is no support in the contract. If that's right, there's no reason why this contract should be any different from any other contract, and it presumably would mean that every contract entered into by one member of the group would be entered into by all 12 members of the group, one assumes. And again, in my submission, what the Learned Friend is doing there also is piercing the corporate veil, which is what we say that the judge did. So, well, I think, unless there are anything further, those are going to be my submissions. Can I just mention in passing, I've put in the bundle the new edition of my book. I don't rely on my book in court. Firstly, I don't want people thinking I'm dead. There's a judgment of Sir Richard Scott where he says, counsel was unable to provide any authority in support of this surprising proposition, save for a sentence in his own book. And I thought, I never want that to happen to me. I've done it simply because the judge had the previous edition before her, and the Learned Friend makes a somewhat curious submission about the fact that the book is no longer relied upon. And there's a passage about the judge's decision, which I wrote before I was instructed. But you can make of what you want in respect of that. But it's there for you, but I'm not seeking to rely upon it.
And you're not relying on it, but can I just identify that we're talking about tabs 27 and 28? Because if we are, those are the
27, 28, yes, and those are it's an addition beyond the one that the judge had.
Well, if it's of any assistance, I've read those and marked them up. So whether I'm relying on them, we wait and see. But
well, I've obviously I've got rather ahead of my estimate, I think. Is there anything else I can assist?
Can I just ask this? Obviously, the principal issue is the question of the duty. That's the first issue, and the second issue is the point you've just been developing, the extension. the third issue in front of the judge, which was obviously dealt with very shortly and effectively as a consequence, was the point about the likely breach.
Yes.
And she effectively dealt with that very briefly at paragraph 60-61.
Yeah. I'm not seeking, if you're against me on both 1 and 2,
Yeah.
I'm not seeking, I mean, we've got very little information inevitably about the relation to the 2, but I'm not seeking to have it to rely on a separate ground in relation to that.
Can I just make a note? That's what I thought, but I'll just make a note of that. Fine. Thank you very much, Mr. Hollander. That's very efficient. Yes, Mr. Stewart.
My lords, my lady, I can't decide which of 2 opening lines to use. The first is, what part of no conflict do you not understand? The second is that Mr. Hollander's book is like the curate's egg, good in parts. Both of them will be part of my submissions. Can I start by dealing with some basic principles which I submit are helpful when looking at this issue? The first is, what do we mean by a fiduciary duty? The answer is that it is a duty imposed by equity in particular circumstances on a person or organisation stemming from the underlying nature of the relationship. Second, it follows from the definition I've just given, and it follows from citation which is common ground between my learned friend and myself, that to refer to a fiduciary is an inelegant form of shorthand. Because in truth, a fiduciary is someone who is subject to at least some fiduciary obligations imposed by equity. Thirdly, in looking to see whether fiduciary obligations arise, you start by looking at the nature of the relationship, and it is common ground and supported by authority that in doing that, if there is a contract, you have to look at the contract, because the contract can expand or contract the obligations which equity would otherwise impose. Moving away from equity to the common law, and certainly on this side of the bench, more familiar stamping grounds, when one looks at a contract, one has, of course, to construe its terms against the factual background in which it was made. One has to look at the words which are used, the context, and the expectation of the parties. Last proposition, before we have a brief look at the facts. There are many and different types of expert who give evidence. It is, with respect, not particularly helpful to say that there is a universal one-size-fits-all approach to experts in the context of deciding what duties they owe their clients. Just to expand upon that a little before going to the facts, a handwriting or document examiner expert might be one example of an expert with a defined field of expertise, document analysis, a limited role, please look at this document and tell me whether it is genuine or not, and no real influence, ongoing role, backup or support in relation to litigation. Moving down the scale, accountants, such as the sort of litigation support which one sees in Bolkia, of course, primarily a confidential information case, but nonetheless litigation support providers, may very well have a much more extensive role. Delay experts, my Lord Justice Coulson was customarily modest about what he has said previously about delay experts. I would venture to suggest that this court is well able to understand that when delay experts are ordinarily engaged in relation to litigation, they take on an important ongoing role in which the final giving of evidence by one figurehead is a very small part of their overall function. The same, I would venture to suggest, is true of quantum experts. I'll address briefly the evidence which we've put in and seek permission to put in about the role of the quantum expert M, appointed together with his team by the third party. But what that evidence showed was that M and his team went into the third party's documents, rummaged around in those very considerable documents, put together the voluminous quantum appendices which formed part of the statement of case in arbitration against my clients, such that the solicitors acting for the third party in the arbitration are unable even to say what documents were inspected and looked at for the purposes of putting together those quantum appendices.
What you say that shows the degree of delegation?
Absolutely. It shows them undertaking, and I hasten to add, not improperly. I'm not suggesting that absent what we say was the wrong done to my clients as a result of acting at all, they would be acting wrongly, but that is at all unusual that we have discovered that M and his team were doing a task which could have been done by solicitors, possibly even by some poor benighted team of junior counsel, of selecting documents, putting them together, coming up with quantum and so forth. Those are the preliminary points that I wish to make before dealing, if I may, very briefly with some of the facts. The structure I propose to take for my submissions is first of all to look at a few of the facts and to emphasise those facts. Those facts are primarily going to two matters. one of them I've touched on already, which is what was expected of the experts engaged in this particular case. Plainly, primarily K and his team on my part, and M and his team on the part of the third party. Secondly, to look at how it was that X, Y, and Z, and indeed the other companies within the group, were being put forward, not just to my clients, but to the world, as being part of a unified provider of expert services. When I've done that, to look at what is meant by the term conflict of interest in the retainer letters, then to have a look at a few of the authorities with a slightly different eye to that of my learned friend, then to look expressly at the different company argument.
By that you mean the what I think of inelegantly doubtless as the extension from X to Y.
Yes.
Yeah.
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 And just to be clear about that, if I could just take you in the core bundle, just so that you see it on that point as to how we put the argument in the respondent's notice. The respondent's notice is to be found at tab 12 of the core bundle. Page 112 of the core bundle. And our primary argument is that the judge's argument was right for the reasons she gave. In other words, she was right to impose an equitable duty not to act on behalf of any of the defendants in this action in these situations. Alternatively, paragraph 6, that on the true construction of the letter of engagement referred to in paragraph 11, you've confirmed you have no conflict of interest, you'll maintain this position. Those were binding on the defendant group, including all three defendants, as a whole, in that they were agreed by the first defendant on behalf of itself and such other group companies. So just so you can see where I'm going in relation to the alternative argument that I put in the respondent's notice.
So that would be bound not by the entire engagement, but by this specific obligation?
Absolutely. This was a specific obligation undertaken. Can I then just draw some attention to some facts which are really, in my submission, not in dispute, but it is worth bearing well in mind when construing the background to this matter. The first and obvious point is that the project upon which Kay and his team were engaged in relation to the arbitration with the contractor was itself a part of a much broader project. The scale of the overall project is enormous. You've seen it, but I remind you of what was said in the supplementary bundle, tab 1, page 3. Paragraph 9 my client's investment in this project is truly enormous. This, as you see, is the largest project of its kind to be built in a single phase in the world. The third parties part of it, simply as the EPCM contractor, involved payment of $1.8 billion.
That's the third party.
That's the third party.
Right.
They weren't doing the building.
No.
They were doing the engineering, procuring, construction management.
So that's 1.8 billion.
1.8 billion US dollars. Not building it,
No.
just as it
So I
were.
think the subcontracts, have I seen that? That's
117
about 117 million.
117 million.
Yeah. So that's why you say the subcontract part of a much bigger overall project.
Yes.
Yeah.
And just to identify, I'm sure it's common ground, but to identify the relationship between the two projects, the contractor in relation to whom the K was engaged is making substantial claims for additional monies, both time and money, as a result of delays. A large part of those claims relate to late issues of issued for construction drawings. The responsibility for issuing those drawings lies with the third party. K is therefore engaged in looking at, assessing, identifying those delays, advising my clients on those delays, and if the matter does not settle, going forward to an arbitration. As the evidence discloses, at an early stage, my client notified the third party that to the extent that it was responsible for delays in the IFC drawings, it would be seeking to make claims against the third party. In fact, in the third party's claim, it seeks additional monies, including in part payment of disallowed costs. And the counterclaim put forward by my clients includes allegations of breach of contract, including in particular the late issue of IFC drawings, and in particular in relation to this subcontract, amongst, plainly, a whole series of other subcontracts. Putting it another way, in court proceedings, and if you had the facility to join, the third party could have been joined as a Part 20 defendant by my clients in relation to the claims put forward by the contractor. And
when you say the third party is seeking disallowed cost, is that costs which have been, is there some pain gain share, or is it just disallowed costs because on one side it said, well, that cost is disallowed because it's due to delay, which is your fault?
it's slightly more complicated than that, my lord, but it's essentially that, but it goes both ways, because they say, as part of their claim, there's a whole bunch of disallowed costs which you've already disallowed, which we want to have back. As part of our counterclaim, we've said we've discovered a whole lot more of disallowed costs, which we ought to have deducted.
And so that, I mean, there's doubtless a raft of different allegations, but your point is that delays to IFC drawings is one of the central features of that.
Absolutely,
Yeah.
absolutely. And just as it were, then looking at how we would say there is a conflict, and as it were, identifying in response to my possible opening line of what do you not understand about no conflict, there are a whole series of actual or potential conflicts in relation to evidence put forward. Suppose that K, first of all, advises us that there is a good defence to allegations made by the contractor in relation to IFC drawings. And we proceed to go ahead and fight on that basis and lose. Suppose on the other side that he said there's no defence, and so we decide to settle all or part of the allegations. In the third party arbitration, there will be claims relating to those matters which won't have been determined. There is more than a real possibility of both time and money being at issue, questions being asked along the lines of, well, your colleague, Mr. X, has said this, your opinion is this, how do you explain the difference, and so on and so forth. In other words, this is not some fanciful situation where there is no real relationship between parties or the project. There are complex interrelationships between the claims being made in the two arbitrations and complex potential possibilities now, because both of these arbitrations are still ongoing, as to what's going to happen in the future in relation to evidence and so forth. Secondly, picking up a point which my Lady Justice Carr has already identified, and just looking at some of the invoices which have been being put forward, and the invoices we are looking at here are of course invoices being put forward in relation to the 117 million subcontract, not obviously in relation to the overall matter. The first invoice we've got is of the 31st of July of 2019. It's at page tab S2, supplemental bundle, page 39. And what you see in relation to this is, in my submission, precisely what you'd expect to see. Of course, insofar as I'm looking at these documents from the point of view of seeking to construe the contract, they're not admissible, save that I would say that they reflect exactly what the parties would have anticipated to be occurring in relation to the matter. One can see from the contract that there are rates given for a large number of different personnel. And if you look, you see first of all the identified expert on the left of the page with his time put down, with the hours put forward and the hourly rate in dollars. Then you see a whole series of other individuals, and I won't identify who those individuals are, but what one sees, and this is just the first invoice, is that for the period starting with the first on the 13th of June through until the date of the last entity on the 28th of June, a total of $64,000 is charged. You have precisely the same form going forward with effectively monthly invoices. I'm not going to obviously look at them all, but if you see, for example, at page 51, you see the same pattern going forward. At various different times, there are different individuals being identified. The total charged by the company X up to and including the January is 600. I've lost the reference. Anyway, it's over $600,000. There is no, there's nothing in any of these invoices which suggests you're getting close to the point of the expert report. This is all the preliminary analysis and so forth, running from July of 2019 through until January of this year. It involves looking at, assessing events, documents, and so on and so forth. It is all litigation preparation, and it is all very substantial litigation preparation. So far as, therefore, in my submission, what the parties understood would be happening is that, of course, they expected, and Kay fully understood, that he would be giving evidence in due course in an English-seated ICC arbitration with essentially, effectively the same CPR rules governing him as to his duty to the tribunal and so forth. But before he got anywhere near that, it was understood and agreed between the parties that there would be a vast amount of litigation preparation. The Lordship and Ladyship have obviously read the letter. My Lord Justice Mayles referred to the reference to assisting with disclosure requests. In my submission, my clients were fully entitled the expert to be on their side in terms of this litigation, in the sense that they would expect him to point out problems and difficulties in relation to potential claims. They would expect realistic advice to be given about those potential claims. They would expect him to understand that their settlement strategy, what they were going to do in relation to these claims, whether they were going to seek to pass them on to third parties and so forth, would be influenced by his advice, and all of that would take place long before the shiny copy of the first expert report analysing the delays was put out there. Touching, if I may, briefly on the second supplementary bundle, and just identifying the relevant obligations which we now know were undertaken on behalf of M and his team.
Mr. Stewart, just before we do, I think it is clear, but can I just confirm that obviously we'll look at this material of NSA and we'll deal with it in our judgments. There's no point taking up time with a separate debate now, but nobody should think that we have, as it were, ruled that this is admissible because it's objected to by by Mr. Hollander's client. So that's the basis on which we're looking at it. I think that's clear, but it's as well to make it
yes. But first of all, that is absolutely clear. It's the position which Mr. Hollander and I have agreed should be taken. I propose to take the question of admissibility very briefly. We have put in a skeleton argument in relation to Ladd and Marshall and so forth.
Yes.
I may say a couple of very small words about that, but for present purposes, I fully accept you're looking at this to Ben essay. It wasn't before the judge, and I'm taking it in that context, if I may.
Yeah, fine. So the material that we're looking at, this relates to what I think of as arbitration 2, the third party arbitration.
Absolutely.
Yeah.
And the critical letter is a letter from the third party solicitors at bundle, second supplementary bundle, tab 4, page 20.
Mm-hmm.
This is part of a spat. We can look at the spat if we want to, but it's part of a spat at getting documents out of the other side in relation to the basis for the statement of claim which had been served in the arbitration by the third party. And one sees in the second paragraph, in particular, and then A's appointed expert has been asking the third party's appointed replacement expert, and you've been asking us the details of exactly what the defendants did and precisely what documents they looked at in quantifying the third party's claims. We in the expert have answered as best we can, but it seems you and your expert want something more. The practical reality is that neither the solicitors nor the current experts actually prepared the quantum appendices. They were prepared by M and his team. Neither the third party nor the solicitors kept a record of precisely what documents the defendants looked at, nor did we ask the defendants to write down exactly how they went about their analysis. Expert meetings not being until July and reports not being due until 2021, but rather the focus on what was required to plead the third party's statement of claim, namely preparing the quantum appendices and identifying the documents that supported them so that the third party could disclose them to A. Didn't anticipate that A would take the action it did to deprive the third party access to the defendants, and the effect of the court order that A sought and obtained is that nobody can now talk to the defendants and his team. So what we say is absolutely plain from that is that an absolute early stage of this second arbitration, M and his team at Y selected the documents, prepared the quantum appendices which formed the basis of the claim against my client, and their involvement was such that the solicitors cannot even identify what it is that they've seen.
And so, just for my note, these are quantum appendices attached to the particulars of claim?
Particulars of claim, and those particulars of claim are essentially for additional monies by which the third party claims. Those additional monies fall into a number of different categories, as you would expect, but they include the return of disallowed costs, alleged entitlements to additional monies, and so forth.
Right. And the particulars of claim, together with those quantum appendices, were served roughly when?
I can give you the precise date, but they were served in the early part of this year. I can give you the precise date, my lord.
Because I assumed that because there's a reference subsequently to the disclosure of documents.
The tribunal's effectively ordered an ongoing disclosure of documents.
So earlier this year, early this year, because it must be before 23 March.
Exactly.
Yeah. Okay. Thank you.
Now, the second part of what I want to do is to identify just how it was, and this is really the material which supports the judge's finding about marketing and so forth, which shows how the defendants collectively marketed, organised and dealt with the world as a separate group. The first thing is that the name, being the first name of each of the individual companies, is used as a shorthand in a way which, as I shall show, is consistent only with a reference to the group as a whole. And can I show you a number of documents which show that that is the case? If you have the supplementary bundle of documents in front of you, and start with the contract documents themselves at supplementary tab 2, page 16.
I shall look at those in the core bundle.
I'm sorry,
That's where
I'm
I
sorry.
mark them up.
Yes,
That's all right.
the core bundle reference.
Yeah, that's right. The core bundle is 139. Yeah.
If you look at the reference, of course, this is addressed, and it's plain that it is addressed to X for the attention of the individual testifying expert. Then, if you look over the page, you will see the various tasks which are undertaken. We haven't really focused upon the confidentiality agreement, but the confidentiality agreement, which is on page 140, acknowledges that they're bound by the terms of the non-disclosure agreement, and that non-disclosure agreement is at page 143. Now, that confidential agreement is entered on its face between the solicitors acting for my clients and X. And if you look at 143, the obligations undertaken in relation to that are that X shall hold all confidential information in strict confidence, etc. And the definition of confidential information means any information in possession of a KNS entity relating to its representation of its client that is disclosed to a recipient or the recipient otherwise obtains in connection with its engagement for the provision of expert witnesses circumstances. And then 4, just looking at how wide this is, under no circumstances shall the recipient at any time, without the prior written approval, acknowledge to any third party what is or is not a part of the confidential information, nor shall the recipient acknowledge to any third party the execution of this agreement, the terms and conditions contained therein, or the underlying discussions, etc. Now, the obvious point that I make from this, and one will see from the evidence when one looks at it from N, the Chief Financial Officer, is that there was a unified conflict system for the group as a whole, that the question as to whether there were or were any not any conflicts for the purposes of the group as a whole were discussed by him and another individual who I think we haven't actually got abbreviation for, but was in fact a common director of each of the 3 defendants. And the defendants saw nothing wrong for these purposes in considering whether there were or were not conflicts across the group as a whole, notwithstanding the confidentiality agreement that they had entered into. That can only be on the basis that they themselves saw that the group as a whole was bound by the relevant requirements. Otherwise, they had no business whatsoever providing any information, any documents, any acknowledgement, or anything at all to any company other than X.
To the extent, if at all, that you're relying on that as a point of construction of the contract, is that information that was common to both parties, or only something that's come out in the course of this litigation?
I will submit, when I've shown you the totality of the information, that both parties would have understood from the totality of the information that the defendants as a whole operated on one basis, that indeed the documents, the conflict searches, which were undertaken and put forward to K initially, which my learned friend showed you, have you got a conflict, that would have encompassed and be seen to encompass the whole of the defendant group. Just picking up a point that you, my lord, made earlier on. Of course, if it was the case that this group undertook a whole series of different things, and some of them had nothing to do with expert services, that would be a different position. But that is frankly entirely unreal. This defendant group seeks to make money, and there's nothing the matter with it, but it seeks to make a great deal of money from the provision of experts. That's its business. It markets itself as providing experts. When someone joins its team, it refers to them joining the first word of each of the companies' team collectively. It doesn't say, we've got boxes here where there's Singapore, London, and so forth. Can I make that good by a series of documents? This is a small point, but it's a small point. Second letter of the engagement, which we were looking at, page 140 of the 140 of the 141 of the core bundle. The following hourly rate shall apply to the members of your team based upon the experience and skills of the personnel involved, subject to adjustment to reflect changes in rates as established by, and then single word, typically on the January the 1st of each calendar year. These rates are in US dollars, shall include VAT, and then they are put forward as being identified. In other words, they're universal rates. The reference to Kay himself, the testifying expert, is as to the MD. If you go to if you go to the emails which my Lady Justice Carr had already referred to, all of these emails, every single one, has a unified
So
base.
this is 104, for example, is it, of the
Yes.
Supplemental bundle?
Yeah, yes. Every single one, by the way, has got unified email system, unified email addresses, no distinction drawn of any sort at all. If one goes back to the supplementary bundle and goes to page 39 and just looks at the cover to one of the, actually if we could perhaps just start with the letter which said that there wasn't a conflict at page 36 from N, the Chief Financial Officer. It's headed on the Z's writing paper. The writer says there is a separate dispute whereby M, an employee in and then the Universal London office would be providing quantum expert services to the third party. You look and see what the offices are, and those are then listed. They include as two of a large number of offices, London and Singapore. Now, the point which is now taken, that there couldn't be a conflict because of the existing offices, was not taken. It's true that the point is taken in the context of information barriers, bullet point, second up from the bottom, but the two experts are separated by geographical and functional barriers, and then you see that the first expert is employed by X, and then just down from that, the second expert is employed by Y. The important point, they then say they're separately constituted entities which are both subsidiaries of the overall holding company. The statement, they don't consider it to be an actual conflict. And then over the page at 37, little point, as a firm providing expert witness services globally, we are free to and do undertake assignments both on behalf of and against an entity in different offices. This allows us to represent to the judges and tribunals we're serious about our fundamental duty of independence and objectivity, as we are not adverse to taking expert assignments against a particular client. So in the very letter rebutting the existence of a conflict, they're putting themselves forward as a global firm, and then there's the confirmation of the information gathering and so forth. Over the page at 38, one sees that second bullet point, electronic files relating to individual engagements are stored in specific project folders within the overall system, and only those with assigned accessing rights are allowed to save and retrieve information from the particular project folders. My Lord, I see the time. There are a number of other documents I want to go to on this particular point. It won't take me very long, but...
well, perhaps we'll pause there. Can I just make a note of that last reference? Yeah, all right. Well, if it's all right with you, we'll pause there and we'll come back at 2. How long do you think you'll be, just as a rough?
I think there's quite a good chance that I will finish and follow my learned friend's excellent example, so as to allow your lordships the misfortune of having tomorrow morning to do other things. I shall certainly endeavour to do so.
All right. Well, let's see how we go. If we do that, obviously the court would be very pleased, but it doesn't follow that that therefore means that's what you have to do. We've obviously got sufficient time.
I thought for a moment you were going to say to have tomorrow morning off, but you managed to avoid it at the last minute.
I wasn't that foolish, my lord.
Come back at 2. Thank you.
All right.